have to strike a balance, because I believe there's no profession that is not engaging. All these professions are engaging. All these things are engaging. So you have to strike a balance between the profession and work. So for us, we don't work over the weekends. And for me, it is a personal rule that I don't pick up clients' calls past 5:30 p.m. So it also gives me a chance to also grow in other social spheres and also just have that personal life. My name is Okoth Odero. I'm a practicing advocate in Kisumu. I was admitted to the bar in the year 2021, and this is my second year in practice, actively involved in court litigation and also conveyancing, that is the land transactions. In litigation, I do both civil litigation and criminal litigation. To be honest, I wouldn't have imagined growing up that I would one day become an advocate or a lawyer, for ease of understanding. I got into high school in 2010. I did my Form 4 in 2013. When I got my grades, when I looked at them, I did well in the social sciences, that's history, and humanities, that's history, business studies, and also the languages. So my result slip favored more humanities kind of field, and that is how I got to choose the career path to pursue law. So what is required basically is actually regulated and stipulated in the law. You must have at least a B plane in English and Kiswahili. You must have a mean grade of B plane also, an aggregate mean grade of B plane for you to get into any law school. So if you fall below that, then you might find your way into a university to study law. But your real challenge will come when now you want to be admitted to the bar, or when you want to get into Kenya School of Law, because Kenya School of Law actually looks at what you scored at the Form 4 level and whether you met the minimum requirements. So minimum requirements is a B plane aggregate with a B plane in English and Kiswahili. Yeah. Of course, the minimum requirements at Form 4 level to begin with. Then, secondly, you must have undertaken an undergraduate degree in law in any university in Kenya or in the Commonwealth countries. There are countries, our system of law is common law. So these are countries that basically adhere to their British kind of system of law. So there are specific countries, and for a country like, if you study law in the US, it will be very hard for you to be admitted into the bar in Kenya. In fact, it's impossible. You can't get admission to the School of Law. So once you're done with the undergraduate, you go for a postgraduate diploma in law at the Kenya School of Law. It's only one institution in Kenya. It's based in Nairobi, Karen. That is where all people who want to finally be admitted as advocates in Kenya and practice in Kenya, that is where they go for their postgraduate diploma, irrespective of where you studied. So long as you want to practice in Kenya, you go to the Kenya School of Law. So the Kenya School of Law, you go there for a period of 9 months. You study 9 units, which is an accumulation of the units you studied at undergraduate. Now that is where now you are taught the actual practice of law. You know, the undergraduate is more of theoretical. So after the Kenya School of Law, if you pass all your 9 papers, then you go for a mandatory 6-month training called pupillage, where you have to work under an admitted advocate of more than 5 years standing for training, mentorship, and just learning. Once you finish that, you go, for pupillage is open to anyone, whether you pass your exams or not, but immediately after Kenya School of Law, you look for a law firm, start your pupillage. Then after that, you submit your clearance documents to the Kenya School of Law. Then you submit them to the council. There's a council that regulates legal education in Kenya. It's called Council for Legal Education. So once you're done with Kenya School of Law, you submit your documents to the Council for Legal Education. Then they forward that to the Supreme Court, to the Chief Justice. That is when you're gazetted to be compliant and fit to be admitted as an advocate. After that, you wait for the Chief Justice now to communicate to you a date when you'll be taking oath of office. That date you present yourself, and you must be physically present. There's no virtual admission. You have to be physically present there, and you take the oath. before the Chief Justice. And finally, you are free to practice as an advocate in Kenya. I wouldn't really be best positioned to comment on that because the number varies from year in, year out. It varies because admissions take place throughout the year. Of course, they've now introduced a new regulation which seeks to have admissions only done at the beginning of the year, in the middle of the year, and at the end of the year, so only 3 batches. But as we speak, I was admitted in March. There was another admission in July last year, another admission in December, another admission in February this year, another admission will come, I think, in April. So the number varies, and but roughly, a rough estimate in 1 year, around 1,000 advocates per year. Because at the Kenya School of Law, the people who graduate every year are between 1,000 and 2,000. Okay, that's a very important and critical question. Get this. All advocates are lawyers, but not all lawyers are advocates. A lawyer is anyone with a degree in law. So what makes you a lawyer is a degree in law, at least as per Kenyan standards. An advocate is a person who has pursued an postgraduate diploma in law and has been admitted to the bar to practice. That is what distinguishes these two people. So you can be a lawyer, but you're not an advocate. But you can't be an advocate without being a lawyer. That is the distinction. We really don't call it demotion, we call it struck off the roll. When you're admitted, you sign, and there's a number that is assigned to you. Personally, I'm number 18,748. So that means by the time I was being admitted, there had been 18,747 advocates admitted before me. So I'm number 18,748, and that is my permanent number. Whether I'm deceased, unfortunately, if I pass on, that number remains. So no one else can ever take that number, and it is on a continuous progression. So once you sign that role, you're now an advocate. Now, your name can be struck off that role if you're found, because there's a whole disciplinary mechanism for advocates, because this is a profession. There have to be cheeky people. Like in every market, you have to find a madman. So in the professional life also, there are madmen. So when you're found guilty of misconduct, there are different levels of punishment. There's admonishment. You can be suspended for a particular period. Then you can be struck off. That is the most dire because it is non-reversible. Once you're struck off, you cannot be reinstated, but your number remains. But of course, you have remedies to challenge the striking off and all that. But yes, an advocate can be struck off, especially if you're found guilty of professional misconduct. I will comment about a day in the life of a litigation advocate, because there are very many fields that once you're admitted to the bar, you can pursue. You can be an in-house counsel, you work for the bank or other organizations that require a legal person to assist them with legal documentation and legal advice. You have commercial transaction lawyers or advocates who basically their role is not really going to court. But for me, I chose the path of going to court, and that is what we do in our firm. So basically, in a good week, I'm in court from Monday to Friday, from 9 a.m. basically until the day ends, depending on on the matters that I have in court. So my day starts at 8. I report to the office at 8. I prepare for my court session. If I'm not preparing for a court session, or if I don't have a court session in a particular day, I'm drafting the documents that are to be presented in court. I'm meeting clients who need legal advice and are bringing in new briefs. I'm consulting with other advocates. And true to what you've said, reading is a mandatory element that we have to go through every day, because even as you make your arguments in court, you have to rely on authorities. You must have read these authorities. Authorities mean the law. Authorities mean decided cases. Authorities mean books. Authorities mean literature books, and all books as you might find fit to use as a tool of persuasion. You can see in this room, it's full of books. Yeah, those are authorities. So reading is a mandatory complement, because you cannot just come and make an argument without supporting it. It will just remain as such, an argument. But an argument that is plausible, an argument that makes sense, and an argument that can authoritatively be used as a tool of persuasion has to be backed by authorities. So reading is part of us, and there's no running away from it. Reading cuts across, whether you're in a commercial transaction firm, whether you're in a conveyancing firm, it is mandatory because circumstances change every day. Yeah. It is interesting when you get paid. That is the interesting bit of it. But I believe the passion comes from you getting a favorable judgment in favor of your client. Personally, that is where I derive my joy. When a judgment is out and it is in favor of my client, and the court basically just reiterates the submissions that I made, it gives me that inner joy that even money cannot compensate for it. So it is a very busy life, but you have to strike a balance, because I believe there's no profession that is not engaging. All these professions are engaging. All these things are engaging. So you have to strike a balance between the profession and work. So for us, we don't work over the weekends. And for me, it is a personal rule that I don't pick up clients' calls past 5:30 p.m. So it also gives me a chance to also grow in other social spheres and also just have that personal life. So my life is not all about the law. I interact with the law between 8 and 5, and maybe when I extend. So I just live a normal life like any other person. Digitalization. Because our courts are still very ancient in their practice. Practice of law in Kenya is still very ancient. We still have handwritten proceedings. We still have bulky files, but the world is going digital. All these things should be reduced into soft copy. All the proceedings should be recorded so that no one misses out on what I say, because we are human. We need to digitalize our practice. That is the future of practice. It has started already, because we can now see courts are now virtual. You can have a witness testifying from the US. You have your bundle of documents, a copy of your bundle of documents. They have theirs, the court has its record, the other advocate has their record. So digitalization is what I would like to change. I'm happy that it has already commenced, and I believe, but we still have a long way to go. Number 2, I would really want to change the way society views lawyers. Lawyers are viewed as crafty people, as corrupt people. I would really want to change the way society views us. So thank you, Victor, and I think let me rush into my next court session, which is set to begin at 2. It's already 2:04.
Oh, sorry.